And now let us discuss what is ejectment. They are summary proceedings designed to provide for expeditious means protecting actual possession or the right to possession of the subject property. The actions for forcible entry and unlawful detainer belong to the class of actions known by the generic name action interdictal, where the issue is the right of physical or material possession of the subject real property independent of any claim of ownership by the parties involved. Unlawful detainer. It is an action for recovery of possession from defendant whose possession of the property was inceptively lawful by virtue of a contract, express or implied, with the plaintiff but became illegal when he continued his possession despite the termination of his right thereunder. So what are the elements of unlawful detainer? First, possession of the property by the defendant was by contract with or by tolerance. Second, eventually such possession became illegal upon notice of the termination of right of possession. Third, the defendant remained in possession of the property and deprived plaintiff the enjoyment thereof. And lastly, within 1 year from the last demand on defendant to vacate the property, the plaintiff instituted a complaint for ejectment. So when is possession considered unlawful? It is only when the defendant fails to comply with the demand that his possession becomes unlawful. A person who occupies the land of another at the latter's tolerance or permission without any contract between them is necessarily bound by an implied promise that he will vacate upon demand, failing which an action for unlawful detainer may be instituted against him. When there is implied renewal of lease, there is no unlawful detainer. An implied renewal of lease will set in if it is shown that the term of the original contract of lease has expired, the lessor has not given the lessee a notice to vacate, and lastly, the lessee continued enjoying the thing lease for 15 days with the acquiescence of the lessor. So who may institute the action and when? In unlawful detainer, the lessor, vendor, vendee, or other person against whom any land or building is unlawfully withheld, or his legal representatives or assigns. And the period of filing is within 1 year after the unlawful deprivation or withholding of possession, discounting from the date of the last demand. The exclusive original jurisdiction over forcible entry and unlawful detainer suits is with the MTC. As a general rule, all actions of forcible entry and unlawful detainer shall be governed by the summary procedure of Rule 70, irrespective of the amount of damages or unpaid rentals sought to be recovered, except in cases covered by agricultural tenancy laws or when the law otherwise expressly provides. And now let us compare forcible entry and unlawful detainer. In forcible entry, possession of land by the defendant is unlawful from the beginning as he acquires possession by force, intimidation, strategy, threat, or stealth. In unlawful detainer, possession is initially lawful, but it becomes illegal by reason of the termination of his right to possession of the property under his contract, expressed or implied with the plaintiff. In forcible entry, no previous demand for the defendant to vacate the premises is necessary. In unlawful detainer, demand is jurisdictional. In forcible entry, plaintiff must prove that he was in prior physical possession of the premises until he was deprived thereof by the defendant. In unlawful detainer, plaintiff need not have been in prior physical possession. In forcible entry, the 1 year period is generally counted from the date of actual entry on land. In unlawful detainer, period is counted from the date of last demand. So let's have a case, Cananay v. Sarmiento, GR number L1246-1947. So for the facts of the case, on or about January 15, 1920, Cananay and her daughter entered into a verbal contract with Feliciano Sarmiento whereby the latter leased to the former the land under an agreed rental of 3 pesos a month. They have so far paid to the plaintiff the amount of 130 corresponding to the rentals for the months of January 15, 1920 to August 25, 1923. Thereafter, the defendant failed to pay the rent since after August 25, 1923. Plaintiff has several times verbally demanded of the defendants to pay the unpaid rentals and to vacate the premises, the last demand having been made on them personally and in writing on August 3, 1946. But they have failed and refused and still continue to fail and to pay the rentals, now amounting to 828, and to vacate the premises. As an affirmative defense, defendant alleged that she acquired the property in question by prescription for having possessed it over a period of 20 years. So for the issue whether the complaint was filed within the 1-year period prescribed, the court ruled that the 1-year period provided therein must be reckoned from the date of the unlawful deprivation or withholding of possession. It is alleged that plaintiff has several times verbally demanded the defendants to pay the unpaid rents and to vacate the premises, the last demand having been made on them personally in writing on August 3, 1946. Under the said paragraph, it is evident that the unlawful deprivation or withholding of possession stated on August 3, 1946 and formal demands for vacating the premises was made. The fact that it is alleged in the complaint that defendant failed to pay the rent since after August 25, 1923 does not make unlawful defendants withholding of possession of the property. Mere failure to pay rents does not ipso facto make unlawful tenants possession of the premises. It is the owner's demands for tenant to vacate the premises when the tenant has failed to pay the rents on time, and tenant's refusal or failure to vacate which makes unlawful withholding of possession.